allow us to make a bill, then we should, and it will become on a secondary basis. حكم ثانوي, I would use the term here. On a secondary basis, it will become wajib to make a will, because if you do not do that, in places like Canada, if dispute happens in the family and there is no written will, the government would then appoint a trustee. And the government machinery takes its own time. And all the expenses of that individual will come from the estate of the deceased. So number one, there is loss financially for that family. Number two, the division will be made not according to the Islamic principles. Certain members of the family will end up getting more than their share. And the more that they are getting is actually considered to be ghasbi and illegitimate from the Sharia point of view. So there are consequences if we don't have a written will. More so when the law of the land allows us to write a will to do whatever we want with our estate. You must have been, sometimes hearing the news that a millionaire, died in New York and left half of his assets for the care of his dog. The law there allows you to do whatever you want to do. And so if the law is allowing us to do whatever we do, whatever we want, then why don't use that system in order to make sure that things are done properly according to Islamic laws? One thing I would emphasize in Canada, at least I don't think it would be that sensitive here, is that when you make a will, although it is according to our Sharia principles, you do not have to spell out that this is Islamic and this is Sharia, because those terms now become, they are allergic to those words. So if it becomes a matter of dispute in the court, the judge might become biased as soon as he reads the word Sharia or Islam. But the law there allows you to do whatever you want. So you can say, this is how I divided it. You don't have to tell them that this division is best according to my, Sharia laws. So this is as far as the importance is concerned. And so this is where we realize that although it is not wajib initially, but if you look at the consequences, it is important to have a written will. Otherwise, some of the heirs will end up being deprived of their Shari'i right, and some will get more than their right, and that will be considered to be a ghasbi. And that has far-reaching implications as far as our religious life is concerned. And the second question that is important to understand here is that from the Islamic point of view, since Islam is not a secular system, it is a system based on the rules of Allah subhanahu wa ta'ala. The question comes up that when we write a will, do we have absolute control on whatever is to be done with our estate? Can we write whatever we want? Well, you have three choices, three possibilities. One is absolute control to do whatever you want. The second option would be absolutely no control, like a communist system. And Islam doesn't agree with either of these two. The perspective of Islam is the third option, partial control through a will. In Islamic laws, when we use the term will, wasiyyat only applies to that partial part of the estate where you have absolute right. Wasiyyat technically doesn't apply to the other, which has to be divided according to the Sharia laws. But for the purpose of making things simple here, we are using the word will, covering the whole process here. And so what is the partial control that Islam has allowed us? If you go to the slides coming up, if you go to the third slide, basically Islam allows you complete control up to the 1/3 of your estate. It's not necessarily entire 1/3. The term is up to the 1/3. You have absolute right to make your decision in 1/3. When it comes to the 2/3, you don't have a choice. Whether you write a will or not, according to the Sharia, the 2/3 have to be divided according to the shares allocated to the heirs in the Quran itself. And so this 2/3, 1/3 issue is very important, and it has, it becomes a very useful tool when we look at certain situations where we would like to adjust the allocation of the shares in the estate. The next is the issue of what is the estate? What is the taraka, as we call it in Arabic? All that a person owns at the time of death is considered to be the estate. If he has given away things in lifetime, that's not part of the taraka. It doesn't become part of the will. The will only applies. Estate means things that a person owned at the time of death. So if somebody has given something to someone else, a family member or outsider, in his lifetime, it's no more his. And that's not even coming into the picture when it comes to the issue of division of the estate. And so when that happens, then how do we go through the process? There are 3 steps. Number 1, before any division is done, all the financial debts, legal or religious, and the wajib portion of the funeral has to be taken out of that. So once those, the debts which were on the deceased have to be paid off first, and when whatever remains, then you look at that, and then you divide that into this 1/3, 2/3 portion. And 1/3 is where it will be dispersed according to the will of the deceased, and the 2/3 will go according to the Sharia shares given to the heirs. Now let me make clear in the first point there, all the financial debts, religious or otherwise. So if somebody, khums was wajib on him, or zakat wajib on him, these have to be paid off before the division. But not the obligations which were missed. Things like namaz and roza or the hajj, which was wajib on the person, that is not considered to be financial debt. That is actually physical obligation that a person did not do. And the only way to take care of that would be that the person writes that in the 1/3. That's where one of the usage of the 1/3 is to specify that you have missed this namaz for so many months or years, or the roza, or the hajj, and that comes out of the 1/3. Another issue which we even discussed in the home seminar was the issue of when we talk about the estate, what happens to the life insurance? Is it part of the division or not? And we mentioned earlier there in the home seminar that when it comes to the life insurance policies, if the beneficiary has been designated clearly, then that insurance policy matures or comes to exist, that money comes to exist only upon the death of that person. When he dies, that money is generated, and it has the name of the owner. So it's not part of the distribution of the taraka or the estate of the deceased. The only case would be where the person has written that the beneficiary would be my estate. So when he dies, the insurance will generate the money, and the money goes to his estate, then it will become part of the whole kitty there. Otherwise, if there is a person designated as a beneficiary, a family member or an outsider or an institution, doesn't matter. That money belongs to that individual or their entity. Next, we have an issue. I'm not sure whether it's common here in Tanzania or not, but in Canada and US, the issue of joint accounts and common ownership of the house, residential property. Normally, I would say almost 100% of the people there, when they have their residential home, it is in the name of both the husband and the wife. Not both always contribute to it, whether it's down payment or the mortgage, but it is legally in the name of both. According to the laws there, when one spouse dies, the whole property will go into the ownership of the surviving spouse. And this also happens with the accounts, because they have the name of both husband and wife on it. When one dies, other becomes the owner of the entire, the account. But there's a tension there, because from the Sharia point of view, that's not what happens automatically. From the Sharia point of view, if there was a property or an account which had the names of both spouses there, technically they are only owners of 50% each. So when one spouse dies, 50% is the property of the surviving spouse, and the other half becomes the taraka, part of the estate of the deceased. And that's where the tension comes in between the legal laws and the religious laws. So what is the solution? There are 2 or 3 ways of dealing with it in the Canadian context, and I would like to share with you so to get some ideas of how things can be done, that you are able to fulfill the religious obligations as well as the legal situations there. Number one, and this doesn't happen with many people, if half of the property, the value of half of the property, or the money is sitting in the accounts, if they are all within the 1/3 of the total estate of the deceased, then a simple solution would be that the deceased should make a will that when I die, the remainder of the property where my wife or the husband has the name and the accounts will all go to him or her. Because then you are using the 1/3 option that Sharia has given to you. But if the value of 50% of the house or 50% of the accounts that you have in joint names are more than 1/3 of the total estate, then we have a problem. And a simple way of resolving that would be that you make a will, but before you make a will to leave it to the surviving spouse, you have a discussion with the immediate family members who are the potential heirs of yours. Explain to them what you want to do. If they agree that, okay, we don't have a problem in this, basically what they are doing is that they are giving up their share in the property and the account, and they are willing that it be given to the surviving spouse. If they give their consent, then there is no problem from the Sharia point of view at all. A third solution, which is not there in the PowerPoint, would be, you give it, especially in case of the husband giving it to the wife. You give your share or the whole house to your wife, because this is known as a hiba, and there's no problem there. And when you give this to her in lifetime, you're not talking about a will anymore. Sometimes people say, no, but I want to give it to her. I say, okay, give it to her then now. You don't have to then deal with the rules of inheritance. But then somebody came to me and said, but what guarantee do I have that she will be my wife till the end? That's where we said, okay, let's find a solution there. And I hope the sisters don't be angry on this issue. But this can go either way. There is another kind of gift in the Sharia known as hiba mashruta, conditional gift. So the husband can say, in the lifetime that I'm gifting this to you, as long as you are alive is my wife. Because there was another question raised that, well, I gifted to my wife and she dies before me. Then that's my house. Now there is a portion of it which belongs to her parents as the wife. And I don't want to do that. I'm sure they can't say that to their in-laws and pay or face-to-face, but this ideas and thoughts come to mind. And so this is where this conditional clause can be added in. That yes, I'm gifting this to my wife or husband, provided, we remain in that relationship, while we are alive. If we predecease one another, then the property will revert to the other person. And so there are ways of dealing with this situation. Now coming to the issue of 1/3 and 2/3. What you see in the next slide is basically just an example of how our fuqaha, the mujtahideen, based on the hadiths from the imams, recommend how to use the 1/3. This is this recommendation or an idea. Number one, use the 1/3, the thuluth, for charity. Number two, for giving to those relatives who have no share in the estate. So you might have a brother who doesn't have a share in your estate because you have parents or children, so the brothers don't come into the picture or sisters don't come into the picture. And you feel that you want to give something to them. This is where you use the 1/3 option. Give to those extended family members who do not share in your estate. Or you can give even to somebody who is going to be your wife, from your children or parents, but you think that they are more in need than other heirs. So there you can use always the 1/3 option to give more to them than the others. And it can also be used for fulfillment of qada namaz and fasting and hajj. This issue of qada namaz and fasting and hajj doesn't come out from the entire estate in the beginning. This can only come from 1/3 if the deceased has made a will about it. Now, who are the people who will inherit? Who are the warasatat, as we call them? Basically, there are three classes, or 3 degrees of heirs, and they are classified in 3 classes because if there is someone from class 1, then those who are from class 2 and 3 do not come into the picture at all. Or if there is no one from class A, then there are people in class 2 and 3. Then those who are in the second category will get it, but those who are in the third category will not come into the picture at all. And so the normal division, the way it is done, is that in the first class you have the parents and the children, or in their absence, the grandchildren. The second class of heirs is grandparents, siblings, and their children. And then the third category is of parental uncles and aunts and their children, and maternal uncles and aunts and their children. And so the way it's done basically is that, once you have people from, if you go to the next slide, if we have people from the first class, your parents and children, even though grandchildren would be there, but because there is a generation gap, there is somebody in between them, so they will be barred from it. So the children will get it, but the grandchildren will not get it. One of the issues where we, get a question on this issue is that suppose a person has, 3 sons, and one son dies during the time of the father, and he is married and he has children. And the grandfather now says that I would like to give a portion to my grandchildren. But he has two other sons who are, living. Because of the presence of the two sons as the children, the grandchildren will be barred from that process. So this is where 1/3 process comes into picture. Then you can use the 1/3 option in order to give a share to the grandchildren who are not eligible for inheritance in that situation. Let's go to the slide which talks about basic shares of your most common heirs. This is based on the ayat of Quran, where Allah subhanahu wa ta'ala has talked about it. And basically what you see here is that you are being put as the deceased, you are the one who are writing the will, and this is how the shares will be allocated. The share of the father, if you have a child, it will be 1/6. If you don't have a child, then everything goes to the father. In case of the mother, if you have a child or a brother, she gets 1/6. Because you don't have a brother who would take care of the mother, so her share has been increased. The share of the husband. If you have a child, then the husband's share would be 1/4. If you don't have a child, then the husband will inherit half of your estate from the wife. The reverse of that, the share of the wife. If you have a child, then she gets 1/8. And if you don't have a child, she gets 1/4. As far as children are concerned, there is no specified share for them. Once the share of the spouse and the parents have been given out, whatever remains goes to the children. The only thing is that the way it is divided, the male children will get double of the share of the female children. And that brings us to this question that, why does Islam treat daughters differently from the sons? Number one, it's not a sexist issue. It's not about gender. Because one is female and other is male, therefore, the male automatically gets more and the female gets less. That's not the issue. It has everything to do with the financial responsibility that Islam has placed on certain individuals in the family line. Because what happens is that Islam looks at the family system that we have. The husband is the one who has to maintain. He is the one who has to provide the nafaqah for the wife and the children. It is not the wife who is obliged to do that. Even if she is earning, it is not her duty to contribute to the maintenance of the family. If she does it, it's out of her law, and the husband has to appreciate that. That is not our duty or obligation. And so the burden religiously has been put more on the husband. So when his father dies, for example, and he has a sister also, the burden of the sister is now is on the shoulders of her husband. Whereas the son now has his own family, and the burden is more on him compared to the sister. And so looking at the burden that Islam has put financially on individuals, that's where when the wealth is divided from one generation to another, Islam says we don't look at just relationships. we look at the burden of responsibility. Wherever the burden is heavier, the shares would be increased there. Because Islam believes in, linking rights to responsibilities. It's not just an automatic issue. So the same idea in a more graphic form would be this diagram that I have in my book. That you see the son and the daughter. The son has a wife and 4 children. Although this is more than the Canadian standard, but probably it's applicable for Tanzania to have 4 and more children. On the other side, the daughter becomes the responsibility of the son-in-law. Whereas the son has the responsibility of his own immediate family. And since the burden is more heavier, the shares of the son is more than that of the daughter. But then people say, well, there are situations where the son would be well off. He doesn't even need the inheritance from the father. And maybe the daughter and the son-in-law are not that well off. They are more in need. And this is where the issue of 1/3 option comes in. That issue of third, how do you use it? It has a lot of flexibility. And that's where you can see that, okay, you have a son and a daughter. Your son is okay, but the daughter is more in need. You can either give a portion to her even in your lifetime. So it doesn't even become part of the division of the estate. Or you can make a will where up to 1/3 you can give it to the daughter. And so we have an example here where you see, for example, without using the 1/3 option. And we are talking about a scenario where you just only have a son and a daughter. So the son will get 2/3 of it, 66.66%, and the daughter will get half of it, 33.33. But then you can take the whole thing and use the 1/3 option. Equalize it. So you take the 2/3 first, divide it, 2 shares to 1 share. So the son's share will become 44% point something, and the daughter's share will be 22% point something. Then you take the 1/3 and you shift it around, and you give 5.56 to the son and 27.78 to the daughter. In the end, all of them are getting equal. So you have all this, flexibility in the Sharia law as far as, and this is done through the 1/3 issue. The next 2-3 slides are basically more about, talking about the book that written on this issue. Basically, it's a book which talks about the most common cases where we have charts for both with 1/3 and without the 1/3 options. Different scenarios. It doesn't cover all cases. But these are the most common examples that we have, and inshallah in the next edition we have increased the numbers of the charts by looking at some of the questions that I get quite a lot on this issue. And so the format of the book is basically, first we have a general discussion about the will, about 14 pages, and then we go through the entire section where we have the charts for all different scenarios. You have to go to the list to find which draft would be applicable to you, and pick that, and you will know, okay, this is how the Sharia would want you to write your will. And then at the end, of course, more keeping in the Canadian environment, we have an example of the Islamic will, which is just as an example, and people can customize that according to their own situation. At the end, let me end with the last slide. This is just a suggestion from Sheikh Mufid's book on this issue, where he says how to allocate 1/3. Just an idea where he says even the 1/3 he divides into 1/4 for Qadha, Namaz, Roza, and kafala, 1/4 for the relatives who do not inherit, 1/4 for deserving poor Salaam, and 1/4 for the poor Shia in general. And of course, this is just an idea that, there is a lot of things you can do as far as the 1/3 is concerned. All different situations which you might not consider to be normal, you can handle that by using the 1/3 option. And even if you need to use more than that, then the only way is to bring all the potential heirs together, explain what you want to do, if they agree, because some of them will then end up giving up a portion of their share. But if they give the consent, then from the Sharia point of view, there is no problem there at all. I end here. Any questions? We'll open it now. Any lawyer here who can highlight the situation whether in Tanzanian laws, is there Sharia laws in any way in picture or not? Or they don't consider that, recognize that law? The step-children do not inherit from their step-parents. No. So there, if the parents want to do something as a step-parent, then 1/3 option would be applicable. Similarly to cases where somebody might have adopted a child, that child does not have the automatic right in inheritance. And so that's where again, either you deal with it in your lifetime, or if you want to live it there at the level of the will, then you can only write up to 1/3 for that.
I just wanted to contribute a little bit on what you had asked about the law in Tanzania.
Yes.
The late father Marhum Sayyid Muhammad Rizvi had written a book on defending Islamic laws with the constitution of this country.
Oh.
And may Allah raise his status. And in that book, it has been clearly pointed out that until now, the regulation which was passed in 1969 about the inheritance laws, in which he had participated in formulating the Islamic laws which are applicable in this country, were still applicable until recently when there is a debate on the changes of constitution. So it is high time that the defenders of the Islamic law do contribute in the constitution which is trying to change these laws in forming it more a secular law. This is just a point of information, and in it is very clearly mentioned about this 1/3 and female and male proportions and other defending issues. So this is just a point of information.
I think this is something which you have to take it up as a community. And I don't think it's something which can be done by one group. I think you might have to, reach out to other Muslim groups so that the Shias and Sunnis or all different, sects and sub-sects can get together, and then that will become a more powerful voice as far as, making sure that the Sharia laws are recognized in this country.
Assalamu alaikum. So, just for information only, what Professor Karim has just mentioned the Africa Federation at the moment has got a team working on this constitution. Recommendations are being worked out by a team of committee members, and inshallah we'll be submitting to the government very soon. And in that we have also the inheritance law according to the Islamic Sharia.
Which state?
That applies to Kenya as well.
Okay, there is an interesting question here since we talked about namaz, that the father, has not left much behind and was not that regular in doing the namaz. Is it wajib on the first-born son or daughter to do the namaz? Well, you hear quite a lot about it. To some extent it is true, but it's not that if the father was, careless and negligent about namaz, then the oldest son has to fulfill it. Otherwise, being the oldest son will be a curse in many cases. What it means is that when the father was in the illness situation or last days of the life, because of the health, was not able to fulfill the namaz, those namaz are the ones which will become wajib on the oldest son. The wujub is not for the oldest daughter. But that does not prevent if other sons or daughters would like to fulfill the obligation of namaz. Sometimes we think it is only the oldest son who can do it. And if others want to do it, they have to seek his permission. There is nothing like that. It's not the right of the oldest son. It is the duty of the oldest son. But other children, not only other children, anyone, even a friend can, say, okay, I want to do something for my friend. He doesn't have to ask the permission of anyone. He can just do the qada namaz on behalf of his friend. So keep that in mind that there is a duty on the oldest son, surviving son. But others, if they want to do it, they can do it. Or even if they want to hire people for namaz ijara for their father or their friend, there is no need to ask permission from anyone. There is a question here.
There was one slide there which was misunderstood. If we can go back, the quarter and 1/6 and 1/8. If that slide would come up.
Okay, we have that slide there. It will be the 11th slide. You see, in case of the mother share, I usually go more down, but it says basic shares of your most common heir. Yeah, that line on the mother, it says mother share is 1/6 or 1/3, depending on whether the deceased is a child or a brother. Here we are not talking about whether the brother can inherit or not. The issue is that the person has died, he's leaving a mother, but he also has a brother, which means that the brother can take care of the mother. So her share would be normal as before, 1/6. But if there is no brother or child of the deceased, so the mother is there without any other child to take care of her, then her share goes up, it becomes 1/5. It's not an issue whether the brother inherits or not. The presence of the brother increases or decreases the share of the mother.
Not regarding inheritance. I was just saying if it is the first category, it is the children and the parents.
Yes.
It's just because they have a child. So, brother, why does he reduce the inheritance of the mother? Because in the case of father, there's nothing mentioned as a brother or something.
The reason why we're talking about is mother is supported by others. And if the brother is there, his presence, the brother of the deceased, this brings the share of the mother down to 1/6. And if he was not there, then it goes up to 1/3. There's a question here that my daughter has verbally given me all her estates, money and jewelry, not in written form. And I'm a widow and I have a son. Is it right? It is her right to do that, but I will tell you that when such things are done on a verbal level without any written support, it is most probably going to be disputed later on. If there's anything like that, either you deal with it in lifetime and give it away totally, or if you are saying that, I'm living this as a taraka, then of course 1/3, 2/3 issues comes in. And that also should be done in a written form. Because, mal is the biggest source of it doesn't recognize relationships. And so if these things are written down, it is the best.
You had said that the estate is what a person owns at the time of death. Is all debts legal or religious? Now, in your first presentation regarding homes, you said that homes is the obligation of the person. So if you know that your father hasn't paid homes, for example, over a number of years, and now you want to pay that obligation, where does calculation start? Does it start from number of years or the time of death, 1 year from that? Second thing is that if you talk about legal debts that people owe you, are those the ones only in writing? Because then people will come out of the woodwork and they'll say, oh, he owes me this money and all that. So what does the Sharia say that?
Well, the first issue about homes was that it had an impact on you. That person was responsible for it. Other marajir, including Ayatollah, always used to say that if you're sure he is not paid, then you have to pay for this money. Well, no, not the present year. You have then to look at the entire estate at that time. Pay the homes and then leave the rest. When it comes to the issue of debts, again, the way I mentioned about this daughter giving to the mother, it should be in written form. When it comes to debts, Quran has an ayat. The longest ayat of Quran in Surah Baqarah at the end is about this issue of putting the loan agreement in the written form. And when that doesn't happen, things become difficult. And so if you are sure that yes, this is a debt, then you as the heir should make sure it's paid off. But if somebody just makes a claim and is not able to provide witnesses or a written document, then it doesn't apply.
in your presentation, you gave scenarios of a son and a daughter, where the daughter has the husband to take care of. Take a situation where the kids are much younger. We have a 15 and a 10-year-old. A 15-year-old daughter and a 10-year-old son, both the father and the mother, or one of them passes away. Then the division is, again, the son gets more than the daughter. So where you said that Islam weighs in terms of responsibility, a 10-year-old son has no responsibility at that particular moment. So how come the division is not 50-50?
Well, you're looking at normal situations, and even in Islamic laws and legal laws also, you don't give the inheritance to a 15-year-old son until they reach the age of maturity. In Quran, there is an ayat where Allah subhanahu wa ta'ala says that the guardian of the orphan would maintain the property of the orphan and manage it for their interest and hand it on to the owners once, not when they reach to the age of bulugh, rather they reach to the age of maturity, which is, financial maturity. So by that time, of course, they will be in that situation of taking on the responsibility. The marriage will be there. Normally, when estates are counted, wealth is taken into consideration. Please advise if the ornaments of the woman are considered an estate or not. Definitely, everything that she owns, including the ornaments, are part of the estate. But from what I hear in our communities, mothers, when they become old, they gradually separate it. Start giving it away with the daughters. So if it's done already in their lifetime, then there's no issue. And if it is that, and to something to be dealt with after the death, then the laws of inheritance will apply.
In case a person dies, he did his verbal deed by telling one of his sons, or maybe the wives of one of his sons, that I leave behind these ornaments or whatever wealth, and this is for you and for your children. But no other member of the family has heard, or there are no more witnesses. Would that be considered as a will, in case if other siblings do not allow or are not happy with that?
It's not an easy situation because there were no witnesses, and the person who is claiming is also the one who is going to get it. Even in the Sharia court, that will not stand. And this is what I'm saying: either put things in writing or have other witnesses there who can, support this claim later on. But if the person who is going to get it says, she told me, that's not good enough. The question here is about the shares of the nephews of the grandchildren. As I mentioned, nephews and grandchildren come later on in the generation. As long as we have a surviving parent or a child alive, the picture of the grandchildren or uncles and aunts and their children do not come into the picture at all. And so the shares would be according to their, there's no specific share for nephews and nieces. It will basically be division of male and female.
Sayyid Islamic. So I have a question. It's concerning giving permission. It's applicable in matters of inheritance as well as in marital cases where someone gives their gifts, etc. For example, you said that someone can dispose of one blood rule if he gets permission from living heirs. And what happens if one of the living heirs then revokes his permission, that I get this permission but I understand only? What is the rule? Because we get these problems also in marital cases, where someone is given dahaj or is given some gifts and then says, no, I don't accept. What is the rule of giving and revoking the permission?
When it comes to the inheritance laws, once the other heirs give the consent to the person writing the will, we don't have a problem even though I am deprived of a portion of my share. Once the consent is given, that's it. You cannot go back on it. This issue has to be handled seriously. It's given initially, it should be very proper, I would say a documented meeting within the family members. That this is what the person proposed, and these were the people, the potential heirs were present there, and they agreed to it. And once the agreement is signed, or they give the consent, that's it. They can't go back on it. Yes? On the issue of gifts in marriage, there are all different situations there. Number one, if the marriage is between those who are blood relatives, for example, cousins, then once you give the gift, it is going given. You can't ask that. If it is between those who are not related by blood, then there are different rulings, but I know this has become a controversial issue in many divorces cases. And 2 years ago, I sent a question to Pakistan on this issue. And he says if the gift was given with the understanding that I'm giving to you, with the understanding that you will marry me, so she has fulfilled her part of the deal, she married you, and that's it. Now it will last, that's a different thing. Unless you put a condition from day one, I'm giving to you as a gift, as long as you're going to be my wife. If that condition was added there, then yes, he would have a right to answer that. Otherwise, no. Salaam.
If somebody is barred from the inheritance in his lifetime, now is also Sharia barred him as well, or there's another ruling on that?
What do you mean by barred? Did the father say
Yes, if the father says, I'm not giving you any inheritance, but what about the Sharia?
No, those who have the share, he can bar him from 1/3, but not from the 2/3. Or he can give everything in his lifetime. There's nothing left for that fellow. But if he's leaving things behind, it's only a maximum 1/3 that he can, allocate to others. But otherwise, that person will have a share.
What about Akul Walidain? Does he inherit in Muttar?
Uququl Walidain doesn't prevent a person from inheriting. The only case would be if the son kills the father, intending to inherit, he will not inherit anything. Or he becomes a kafir. Kufr will prevent, and qatil will prevent the person from inheriting. Any other questions? Aqul Walidain का मामला जो है वो what will happen in the afterlife. There is no implication in the inheritance issues.
If
somebody doesn't have any issue and he passes away, two scenarios can arise. Either a single parent can be alive and a spouse can be alive, either the male spouse or the female spouse. What would be the ruling in such a case when somebody dies? He doesn't have children, but one spouse is alive and one spouse dies. It could be the male spouse who's alive, then who inherits? If it's the female spouse, who inherits who, and how is the distribution done? And if, let's say, a mother is alive.
But again, you go to the 3 degrees of relationships. If there are no children involved, but there is somebody from the father or the mother, then everything will go to the father or the mother, surviving parent. Or if there are no parents and there is a child, male or female, they get the whole thing. But if there are no parents and no children, this is where the second circle of relatives come into picture. Brothers, sisters, they will inherit. Or if they are not there, their children are there, then they will inherit. But if there is no sibling, no brother, no sister, no children from them, then you go to the third category where the uncle and aunts come in and their children. So it will be a very rare situation where you have a person who dies without having anyone at the end. But there are also provisions for that. Imam becomes the waris again. When somebody dies, there's no waris at all, even in third circle, then the Imam is the waris of that person.
What happens when, let's say, if I was divorced with my wife, God forbid, and then I pass away, and my wife is still alive, and my mother is still alive, but they were separated. So what would be the scenario in this case? The mother and the wife still inherit together with my children?
The parents would inherit the children in any case. But when it comes to the spouse, I didn't mention that. If you remember the graph, the spouse there spelled out across the chart,
Right.
which means she is or he is never away. Ever present there, in all scenarios. But divorce, he or she is no more spouse. In case of a lady becoming, talaq happens, if the husband dies within 3 months of the talaq, the iddah period, then she inherits. But if he dies after iddah, it depends on how strong is her love. If the husband dies after the iddah,
If I pass away, for example, and I have no wife, for example, but I have a surviving parent, and my children, they inherit me. Does my parent inherit me as well or not?
yes, parent and children inherit together.
But if the children are alive, does the parent still inherit?
Yes.
Even though the children are alive, it doesn't just pass on directly to the children.
The children, the parents first get their share, 1/6 each, and the remaining goes to the children. So the parents and the children co-inherit together.
So in the event that if I pass away, my mother would, let's say, get 1/6, or my father would get the 1/6. It doesn't matter if it's father or mother. There's no male-female issue there. Then after that, then the estate is divided among the wife and the children.
Yes.
So the second division would be for the wife, and then the third division for the children.
Actually, the first would be for wife,
First would be for the wife,
for the parents,
for the parents. So what would be the for the wife, the first?
The wife would be 12 and a half.
12 and a half.
1/6 each for the two parents.
Okay.
The remaining would be for the children.
So if there is one parent alive, does the one parent take 2/6 or 1/6?
Only
1/6. Thank you. If I may ask a follow-up.
Yes.
When you say 1/6 of the total or 1/6 of the remaining?
No, 1/6 of, if you don't use 1/3 option, then 1/6 from the total.
Of the total. So I take out 12.5% of the total first, then I take the total again and take out another 6th.
No. You take the 100%, and then you give the allocations there. 25%, and then what is the 16.16, and then the remaining goes to the children. Well, this is a question which we referred to earlier in a way. If the person has put all his property or the assets, everything in joint names with the wife. And so technically what happens is, at the time of the death, half of everything is the property of the surviving, spouse, in this case, the wife. The other half becomes part of the estate to be divided according to the rules of inheritance. So 50% is already property of the wife. Out of the other 50%, she gets 12.5%. So we are talking about 62.5% of the total. The remaining will go to the children. Unless, as I said earlier, that there is an understanding within the family before, where the children say, we don't want anything. If they agree, then the whole thing goes to the wife. There wouldn't be a problem. Yes, it's not going to be that easy the way you've written it now. What you'll have to do is, the only way it will work is if you can sit down with your daughter and the other children and say, this is what I wish to do. Because your daughter has a share in it. Your other children have a share in it. If they say, okay, we don't have a problem, this is what you want to do, that's fine.
Because I want this property to go to my children after my passing away and my wife.
Yeah, but
as long as we are alive, we become the owner of it.
this is what I'm saying. Then you have to sit down and get consent of your children, because it can't automatically go to the daughter. It has to go to the other children also, unless the other children say we don't
But I
want it.
already mentioned in the will.
If it is within your 1/3 of total asset, yes. If it's more than that, then you can't do that.
What if he were to gift it to his daughter right now on a condition that on him and his wife's living, the income or whatever will come to them, and then after they pass away, it will go to her. So he can gift it now to her on that condition or not?
Yeah, he can do that. This is one solution. So if you gift it, if you make a gift now in your lifetime, not after death, to your wife or your daughter with those conditions, then it can work. No, that's what I'm saying, either to your wife or to your daughter with a condition, but you can gift it to them in your lifetime, not after your death.
Yeah, coming back with the joint accounts.
Yeah.
Sometimes we have joint accounts. We and my wife. Many times my wife doesn't know, she has just the signature that she has got the joint account. Now does she really become an owner, 50%? Technically yes, but
Well, when such things come up, we always look at the document. The document says she is half owner, and she's not half owner, whether she contributed to it or not. Means whenever the dispute will arise, even a Shia judge will have to go with what is written down. If a man passes away and he has performed muta, does the temporary wife become wife or not? What if she has children with him? Well, inheritance between husband and wife in a temporary marriage is not taken for granted unless they agreed on it. Because in temporary marriage, some of those issues which are part and parcel of permanent marriage are not automatically included in temporary marriage. And one of those issues is inheritance. Whether they inherit or not, only if they agree at the time of muta, otherwise they will not inherit from one another. However, as far as the children are concerned, that doesn't matter. Whether they are from muta marriage or permanent marriage, the children will have a right to inherit from the father. If this muta is a secret one, how does the wife get her right? Well, she doesn't get inheritance unless it was part of the agreement. As far as the children are concerned, this is what we are saying. Don't give it a secret. No any other solution.
Malana, if a person in his lifetime gives some amount to one of his heirs, his son, and he writes in his will that after my death, as this son has already been given his share, he should not inherit any amount. Is it valid?
Technically no, unless he, when he was given that, gives a consent that I give up my share in the inheritance. Then that will do.
I've got a scenario. I've read a will of my grandfather. Okay, he had 5 daughters. Okay, he had gifted all the daughters an estate, a property. Okay, and in that will actually it was written that that property is going to be inherited to a daughter and a daughter and a daughter. Now let's say that building is now coming into a condemned. How do we tackle this issue? And because it says that it has gone to my mother has given to my sister has given to her daughter. How do we tackle that thing? And if my sister or my sister is not ready to take care of that building, how do we solve that problem?
I think there is a problem in the initial process, the way it was done. It was not done properly. You can't leave something as part of the estate with this condition that it only goes daughter, and then after that also daughter and daughter and daughter. If you wanted to do it, there is another vehicle in the Sharia known as al-waqf al-awlad, where you can actually make a property as a waqf for your children. And there you as a waqf, a person is making the endowment, can put down the conditions that this will be maintained by the female descendants of mine from one generation to another. They will manage it and use the profit or the proceeds for themselves and their family. So the initial process which was done is not, will not be considered valid. And the best thing would be that if the generation at the moment can sit down with the sister who has the custody now of that and come to a kind of a musalaha, compromise on that issue. And that would be the way to resolve it. Salaam.
This joint account mentioned now, says there's property also jointly owned by the husband and wife. There's a bank account also jointly in the name of husband and wife. Although here you said it is 50-50%, but the joint account, the wife has a full authority of the full amount. And similarly of the property, suppose the husband dies, that means the property will go to the wife without being apportioned according to the share.
That is what we mentioned earlier, that when it comes to the joint properties, she only owns half. The other half will become part of the estate. And we talked about 2 or 3 solutions of how to resolve that problem. One was gifting it to her. Other was to see whether it is within the 1/3 option or not. And the third was to get the potential heirs, to have a sitting meeting with them, and once they consent to that, then there shouldn't be a problem. So there is a solution to it, but it doesn't happen automatically.
So on the matter of waqf, Awlad, this is in reference to probably similar to a trust, for example, in the Anglophone sense. And if such a waqf is done, for example, for the Awlad, do you not in any way affect the rights of the heirs, for example, or depending on which age stage you are? For example, if I decide to do this at the age of 65 or 70, that I take the entire amount of my wealth and convert it into waqf, so that the remaining amount which could be available to the heirs is less. I could be favoring just a certain portion of the potential heirs. Would I not be doing an injustice to the... That's the one question. And the second question is, assuming that I have done work for Awlad, if I'm still alive and if I intend to withdraw that wealth, is it possible to do so? And make changes, or already since it is the property of the waqf, I cannot now any longer touch it?
The rulings about waqf for al-awlad are different from the normal waqf that we do for Masjid Hussainiyah or things like that. There you can specify who are going to be the beneficiary of that. Now whether it is fair or unfair or other areas or not, this is, I'm just mentioning as a possible way of dealing with this kind of situation, but that's not the norm. You don't always do that. And you don't do it for all your assets. Even Amir al-Mu'minin had done this. He had, from ground zero, he had tilled the land to make it usable for farming, planted palm trees in very huge areas. In Sharia, we have a concept of Ihya al-Mawad. If there is public land not owned by individuals outside the town, in jungle, nobody is using it, you revive it by providing water, well, and make it good for cultivation, and you start doing it, it becomes your problem. And so Amir al-Mu'minin had done that very large areas between Makkah and Medina, and even outside Medina. And some of those property he made it waqf in general for sadaqat and khairat. There is actually the concept of sadaqat or Ali, charities of Ali, very common in history during the 25 years of his life. And there were some property he made it waqf for his descendants, making Hassan and Hussein the custodian initially, and then he says once they are not there, the children of Fatima, then others will come in afterwards. And so the concept is there, but no, you don't take the entire estate and whatever you have and then, fix it in that way. But there are ways, and that's why I think maybe this will be the opportunity to talk about it. Now whether you can change the conditions, I'm not sure about it, but it's not a normal waqf like masjid. When you do the waqf for a masjid or a Hussainiyah, you made it waqf for Allah subhanahu wa ta'ala. You are no more the owner of it. This is a different thing. Waqf for al-awlad is a different concept than the normal waqf. There's a request here from the ladies' side that, if I can clarify an issue in Urdu, some ladies, senior ladies are giving a certain amount of funds at the end of every month instead of yearly payment. जहाँ तक फंड्स का सवाल है, ये इनकम टैक्स नहीं है, आमदनी पे ये टैक्स नहीं है, बल्कि ये बचत है, और वो भी हर महीने नहीं है बल्कि साल में। लिहाजा अगर कोई शख्स जो है हर महीने फंड्स उस तरह से निकालते हैं, तो हम हराम तो नहीं कर सकते हैं, लेकिन वो उस तरह से उनका नुकसान ही हो रहती है। उनका फ़ायदा इसी में है कि एट द एंड ऑफ द ईयर वो हिसाब किताब करें और देखें अगर बचत हुई है तो फिर फंड्स जो है उस वक्त इसका मंथली हिसाब नहीं है बल्कि What about the mother qada namaz or roza? Well, the wujub which is there on the oldest surviving son for the qada namaz of the father, it doesn't extend to the wujub on that level for the namaz of the mother. But it doesn't prevent him or other siblings to do that if they want to, or to hire somebody to do their namaz. Why the difference? I'm not sure about it. Maybe Allah subhanahu wa ta'ala is going to treat mothers more, mercifully than the father.
I wanted to clarify on the wife being a joint owner of my estate. Obviously, she's not earned anything. I really put her name as a signature because of UK tax laws. Say, if I were to die, the inheritance tax will apply if she is not a joint owner. Now, if she was to die before I do, then automatically, according to Sharia, her parents would become inheritors of my estate.
Fortunately, yes.
Even though my wife has not earned anything, she is just there as a maid.
Well, that's where we are saying, make a sign, gift on that issue also, or if she gives a kind of a consent that I'm gifting this to you, my portion of the account, that if I pass away before you, it will revert back.
The second question is the distribution. Is the distribution before your 1/3 or after 1/3?
You do the debts have to be paid first, and then you do the 1/3, and then you go to the distribution.
May I come again here? The lady replied that funds is payable at the end of the year. But if I know that my saving at the end of the year, like a budget matter, I know that I have paid $100,000. So I want to pay installment from now only, so that at the end of the year, I balance the book. Is it not allowed?
I'm not saying it is forbidden, or what I'm saying is that there is more benefit for the individual to pay at the end of the year, because they might have make a budget, but maybe in the middle of the year, something happens, and they end up using more as far as their expenses or whatever. So if you do the calculation at the end of the year, you get the actual, figure of the savings. But if you're doing it on a monthly basis,
It's allowed.
yes, she is allowed.
The second question, I was told yesterday or something that if somebody is a Kazan once for 20 years, is it allowed that you can only repay by making salah for 5 years old? Is it right somewhere?
There's no shortcut.
There's no
I know there is an amal going on, circulating in the internet about the last Friday of the month of Ramadan. There's something known as namaz-e-qadha-e-umri, that if you do this, 70 years of your namaz will be forgiven. I haven't yet seen that in any risala or mafati or anything like that. I don't know where people come with all these things.
There is a book which has been published, which has been written by Sayyid Muhammad Rizvi, Writing an Islamic Will. It's available for sale at 4,000 shillings. From the gent side, this side, and from ladies also it's available.
This is the last question here on the ladies' side. It's a very specific scenario, but anyway, just look at it from a general point of view. If a woman has two sisters and an older mother, the mother passes away leaving all her ornaments with the daughter who lives with her. Before she distributes the ornaments among the three sisters, she also passes away. Her husband has taken control over all the ornaments, and the woman has no children. What is the duty of the husband in this case? What is my religious obligation since I know this case? The husband has to be told that this is not his property, and if it is a Rizvi, he has to deal with it. And unfortunately, in this kind of situation, since things are not put in written form, the most you can do is you can advise the person to do nasiha that it is a Rizvi and it's not going to help you with the after. And not everyone